Hi everyone, just thought that it was about time for another one of my Get Reels, get it? And today what I want to talk about is the options that are open to you before going down the route of an employment tribunal. So I am a big believer, after being through the process myself, that, if we can stop the problem at source and we can do more working together, employers, employees, then it really would probably halve the number of cases that had to be taken to an employment tribunal. So today I want to talk about just some options that are open to you when you've suffered a detriment at the hands of your employer. And that can be an act of what you feel is discrimination. It can be a redundancy. It can be on the issue of a PCP, like what happened to me. It can be if you've been dismissed and you feel that it's unfair. So whether you're still working for the company or whether for whatever reason you're no longer working for them, there are things that you can try and avenues you can go down before considering an employment tribunal, and also things that will reflect better on you when you reach an employment tribunal if you've exhausted all other avenues. So the first one would be to check either your employer handbook or your contract, or speak to somebody in a superior position and ask if you can raise a grievance, or tell them that you want to raise a grievance appeal, and have your concerns obviously discussed on a higher level. Sometimes this can resolve something for both sides. It can reach an outcome that's acceptable to both parties. And obviously it can be beneficial for employers, because sometimes, especially managers and people further up the food chain, they sometimes don't realise that these things are happening. So your first port of call really would be to raise a grievance. You may have a template in your handbook, or if you go on a website from ACAS or Valley UK, they offer templates, really just to set out the fact that you're not happy and you would like to raise a grievance or enter into a grievance appeal to discuss any wrongdoings that you feel has been done against you. If the grievance appeal is unsuccessful, as mine was, or if you're refused the right to a further grievance appeal, which again happened to me, you can register with ACAS if you wish to appeal the fact that you still want to take it further, you're not happy with an outcome or anything that was discussed, you still feel that it was unfair and nothing has really been done to resolve it. Once you register a claim with ACAS, you'll be assigned a conciliator. And basically their role in the process is to try and reach something which both parties are happy with. So they will try and basically, as the name suggests, conciliate between the two parties, and they will try and reach a resolve and get some form of agreement in place that both you and your employer are happy with. Now, obviously, that could be financial, or in some cases, it can be that you need a reference, and for whatever reason, your former employer is refusing to provide a reference. I found in my experience, if I'm honest, that their main priority at ACAS is to agree a resolve and try and get something kind of nipped in the bud before you need to take your concerns further and you have to go through the employment tribunal. Even if you know that nothing can probably be, sorted out with ACAS, even if you feel that you've had a grievance appeal, you've come to a bit of a stalemate, and you really think that an employment tribunal is unfortunately the only resolve, you still have to register with ACAS and you still have to go through the process, because you will need an ACAS certificate issued to you to say that you've gone down that route. A conciliator has basically tried to reach a resolve. It hasn't been successful, and obviously the next port of call is going to be to register your claim with an employment tribunal. Now, it's extremely important to me on these channels to be as honest as I possibly can with people, because once you make the choice to go down the employment tribunal route, you kind of hit the ground running. So once you register and you complete what's called an ET1, which is basically your version of events, what's happened to you, you raise your claims, and you put that information down and submit it to the Employment Tribunal, the case is running. So while I would always advocate putting yourself first, and if you start the process and you feel it's too much and you need to walk away for whatever reason, the decisions that you make right at the very beginning can have a huge impact on your choices further down the line. So, for example, if you choose to engage a solicitor, generally if it's on a pay-as-you-go kind of an agreement, once you get to a point that you think enough is enough, they may obviously conciliate, if you like, with the other side to try and reach a resolve and say that you want to withdraw your claim, and they will probably argue on your behalf that as long as the claims weren't bought maliciously, that you shouldn't be obviously put a cost award on you to pay the other side's fees. If you go with a no-win, no-fee solicitor, it's highly likely that in your CFA agreement, so your conditional fee agreement, your no-win, no-fee agreement, there will be a clause in there to say that your solicitor has to agree with any choices that you make. Likewise, you have to agree with any choices that they make. It would be harder to go to a no-win, no-fee solicitor and tell them that, mentally you've had enough and you want to withdraw your claim, because obviously unless they're in agreement, that could potentially leave you with a hefty bill on their side. And obviously if they're not willing to negotiate with the other side to close the case down, you may find yourself with a cost award from the other side. If you are a litigant in person, like myself, so that means that you have no legal representation whatsoever. You do everything yourself, just basically with help from forum sites, websites, etc., etc. You obviously have full control then over your claim. It is a lot harder because obviously unless you're legally trained and you have any employment experience, you are going into the process quite blind and you do have to learn quite fast. You are able in that situation to withdraw your claim if you feel that it's too much. But again, you will have to check with the other party because they could then argue that potentially you're withdrawing your claim because you don't think there's any chance of success. If that's the case, they could argue that you've maliciously brought the claim or you've knowingly entered into the process knowing that your case had no form of success, and they could put a cost award order on you. Now, cost awards against claimants are extremely rare. I think in the last study that was done, only 6% of claimants were ordered by the judge or the Employment Tribunal courts to pay the respondent's costs, but it is something that you have to bear in mind before you start this process. So if you start it, you have to be pretty sure that you're going to be able to continue it, or make provisions or provide as best you can circumstances, which means that if it gets too much for you or your circumstances change, that you would be able to withdraw your claim, because it's a little bit like trying to jump off a moving train for some. If you choose to represent yourself, the preparation is extremely hard. Obviously, you need to be able to identify your claims because the Employment Tribunal won't look at what happened to you and say, right, okay, your claims fall under X, Y, and Z. They expect you to take the information to them, and they will ask for further information if they feel that you have ticked a box or you've brought a claim that they don't feel has any chance of success. Now, obviously, you're going to have to complete your ET1 and you're going to be responsible for submitting all the relevant information throughout the process that the Employment Tribunal will expect. Now, obviously, if you choose to be represented, and that's either with a solicitor of your choice, or if you choose to go down the route of a no-win, no-fee, sometimes if you have insurance on your house or car or any form of insurance, the policies do sometimes cover employment related issues. So it's always worth checking your policy or giving your insurance company a call, because it may well be that you are covered up to a certain amount, and they will then get representation for you. So obviously that's going to take a lot of the pressure out of it. It's definitely worth bearing in mind that the paperwork and preparation side is only one part of the process. So obviously the other side of things is something that I found equally as challenging, if not a lot of the time more challenging, and that's the mental and emotional side of bringing a claim against your employer or former employer. So this can be things like reliving what happened to you, if you submit a DSAR or you get a disclosure order to get your hands on information regarding whatever happened to you and the people that were involved. It can be really, really hard going through them. It can be really hard reading things that you feel are unfair or untrue. Obviously, an employer or a former employer is always going to try and turn things around to, paint themselves in a better light, even if they know that they were very naughty at the time. Things like, finding out that the people that you maybe thought were your workmates, that were your teammates, people who you would maybe have gave a helping hand to and you would expect the same in return. Maybe you find out that really, it wasn't really a two-way street and you are pretty much on your own. That can have a really, really negative impact on you as a whole. And if I do anything over the course of these videos, it's going to be to make sure that as many people as possible go into the employment tribunal process with their eyes completely wide open. I'm not trying to put anybody off, but I do believe that honesty is the best policy. And if anybody ever asks me, what the process was like, I am really honest and I will tell it like it is. And I will say, do you know what? It's extremely hard. It's hard both mentally, emotionally, physically. It's hard, getting the knowledge. It's hard doing research. It literally is just constant. It's relentless. My old saying, if you've watched any of my other videos, forewarned is forearmed. Never, ever is it more relevant than at the start of the process. So before you go down the employment tribunal route, try and speak to people, search for information online. There are some forum sites on Facebook about redundancy and dismissal and employment tribunals. Go on to the government website and search for tribunal judgments along with written reasons. They will tell you lots of information about different people who've brought different claims, what happened to them, what the outcome was. Sometimes it can even include things that the claimant's been through. So it will tell you if they've suffered anxiety, if they've suffered depression, if they've been through counselling, and what help they've had to have from different outlets to get through the process. Because I genuinely believe that nobody comes out of this process unscathed, and if you do, then I take every hat that I own off to you, because I've never spoke to anybody in the year since my final hearing took place that has said, do you know what, went through the process, got a successful, unsuccessful judgment, but you know what, I'm happy as Larry, I'm moving on with my life and everything's just fine and dandy. Never ever have I spoken to anybody who said that. Another thing that I would say, which is really important, never ever compare yourself or your case to anyone else. It's a completely individual journey. Just because it's right for somebody else to take their case to an employment tribunal, even if there's maybe a group of people at your workplace and, there's 10 of you and 9 of you are going down the employment tribunal route, just because it's right for them, it really doesn't mean that it's right for you. And the most important message that I really want to get across today is that you should never, ever take the process as a personal reflection on yourself. So you must never turn around and think, oh, they're doing it, why can't I do it? Why am I struggling? Why do I feel I can't go through with it? It's such a difficult process, and it takes a huge amount of bravery to start any form of process. And that can be raising a grievance, it can be just challenging a PCP, or it can be asking, to lodge a grievance appeal, going into a grievance appeal hearing. I know with mine, I was really daunting. I was physically sick on the morning of my grievance appeal hearing with the managing director. I was shaking. I was in an absolute state. And it's important that people know that, because it is really important. Your life's been turned upside down. It is really emotionally charged. And it takes a huge amount of courage to go through with it. But then on the flip side of that, I also believe that it also takes a huge amount of bravery to know when you need to walk away. And that can be at the beginning. So it can be that your former employer or your employer hasn't treated you very nice or hasn't treated you very well, and may very well have broke, points in law that you could definitely challenge in an employment tribunal. But if you think that the process is just not for you, then it's really, really not worth putting yourself through what could potentially be years of anxiety and stress and worry and work. If you feel that you can just walk away and you can start to rebuild your life, then that's the right path for you. For some people, raising a grievance, just getting some answers from their former employer can be enough. And they feel that they've got the answers they need, that's justice for them, they walk away. Other people will start the employment tribunal process, they'll get so far in, especially if you're a litigant in person. But even if you are represented and you find that reliving the experience over and over and over and everything else that goes with it is just too much, I say, depending on the choices that you've made, it may not be as easy. But speak to your solicitor, speak to your legal representative, speak to the respondents' representatives if you want to withdraw your claim. As long as you haven't brought your claim vexatiously or maliciously, and you genuinely believe that you had a genuine chance of success, then it is highly unlikely, it's not impossible, but it's highly unlikely that they will slap a cost award on you. Because, to be honest, if they know that they've been really naughty, if they know that you've got evidence to prove that they've been naughty, chances are if you talk about withdrawing your claim, they're going to snap your hand right off up to the shoulders. But, and for some people, they think, you know what, it's better to have tried than never to have tried at all. I can't get through the process and I need to walk away. And they're happy with that, and that's their justice, that's their right. Another thing to bear in mind if you do withdraw your claim is that the respondents are probably going to ask you to sign an NDA or a settlement agreement to say that neither party can disclose obviously anything that's happened. So that's something else that you need to bear in mind, and you need to be prepared to probably sign if you are going to finish the process early. Then there's other people like myself who, the final hearing was the only way for me. Because that was, for my personal reasons. And I felt that I needed to have that hearing. I needed to have those questions answered. I needed to, show a third party, look, this is what has happened to me. This is what I've been through. And I needed that impartial kind of party to say either, no, we've considered it. You've shown us all the information that you've got. And, we think you were treated fairly, or, yeah, we've taken all of what you've said on board, we've looked at it, and we agree that your employer did treat you unfairly, and I did say when I received a successful judgment that, it was never about the money for me, that the judgment that I received was worth more than any financial reward that they gave me, and that was right for me. I was very, very lucky. I had a lot of support. I had my partner, I had my family. There are people who don't have that support. And if you don't have that support network, it makes it even more challenging. So really just to wanted to just do this video just to say, that there are other options. Don't automatically assume that if your employer's being a bit naughty or if you're unhappy with something, it has to end up in an employment tribunal, because as long as your employer is prepared to work with you, there are other alternatives before you have to go down that route. But if you do have to go down that route, then you need to make yourself aware of what's to come. Forewarned, forearmed, people. That's enough for today. So that's me signing off, and I'll see you again on the other side. Bye.